What are some of the most significant mistakes that can arise with a limited liability company, LLC? Forming a U.S. LLC is often touted as a simple process, but that simplicity can be a double-edged sword. Many entrepreneurs rush through the setup phase without fully understanding the legal and tax implications of their decisions. From failing to maintain a corporate veil to choosing the wrong tax classification, the errors made in the early stages can lead to personal liability and significant financial loss. This analysis explores the most critical pitfalls that can derail an otherwise successful business structure. 1. Co-mingling personal and business finances. The most frequent mistake LLC owners make is failing to maintain a strict separation between personal and business funds. When you use a business credit card for groceries or deposit a client check into your personal account, you risk piercing the corporate veil. In legal disputes, a court may decide the LLC is merely an alter ego of the owner rather than a separate legal entity. This effectively strips away the limited liability protection, making your personal assets fair game for creditors. Establishing a dedicated business bank account from day one is not just good organization, it is a legal necessity. Failing to adopt an operating agreement. Many states do not legally require an LLC to have a written operating agreement, leading many solo founders to skip this step entirely. However, without this document, your business is governed by default state laws, which may not align with your actual intentions. An operating agreement outlines management structure, profit distribution, and procedures for adding or removing members. Without it, internal disputes often escalate into expensive legal battles because there is no rule book to follow. It serves as the foundational contract that proves the entity's legitimacy to banks and courts alike. Misunderstanding tax classifications. An LLC is a chameleon entity that can be taxed as a sole proprietorship, partnership, S-Corp, or C-Corp. Many owners default to a disregarded entity status without calculating if an S-Corp election could save them thousands in self-employment taxes. Conversely, some rush into an S-Corp structure too early, incurring high administrative costs and complex payroll requirements before the business is profitable enough to justify them. Selecting the wrong tax treatment can lead to overpayment of taxes or unexpected audits from the IRS. It is crucial to consult a tax professional before the filing deadlines pass. Neglecting state annual reports and fees. Registering an LLC is not a one-and-done task. It requires ongoing maintenance to stay in good standing with the Secretary of State. Many owners forget to file their annual reports or pay the required franchise taxes, which can result in the administrative dissolution of the company. If your LLC is dissolved by the state, you lose your liability protection and the right to bring a lawsuit in court. Furthermore, regaining good standing often involves heavy late fees and cumbersome paperwork. Monitoring your state's compliance calendar is vital to ensure your legal shield remains intact. Improper execution of contracts. A subtle but devastating mistake is signing business contracts in your own name rather than as an agent of the LLC. When you sign a lease or a vendor agreement as John Smith instead of John Smith, manager of XYZ LLC, you may be assuming personal liability for that contract. Creditors can argue that the agreement was made with you individually, bypassing the LLC's protections entirely. Every official document, from emails to multi-million-dollar deals, must clearly state the company name. Consistency in your professional identity reinforces the legal boundary between you and your business. Ignoring foreign qualification requirements. Entrepreneurs often believe that a single LLC filing allows them to conduct business anywhere in the United States. In reality, if you have a physical presence, employees, or significant operations in a state other than the one in which you formed your LLC, you must foreign qualify. Failing to register as a foreign entity can lead to back taxes, fines, and the inability to use that state's court system to enforce contracts. Many online businesses fall into this trap when they hire remote workers in various states without checking local registration laws. You must legally exist in every jurisdiction you are doing business. Inadequate insurance coverage. While an LLC provides a legal shield against business debts, it does not protect against everything, particularly professional malpractice or general accidents. Many owners mistakenly believe the LLC structure replaces the need for comprehensive business insurance. If a customer is injured at your place of business or you are sued for professional negligence, the LLC's assets are still at risk, and in some cases, you could still be personally liable. General liability, professional liability, and workers' compensation insurance are necessary layers of protection. Insurance and the LLC structure should work in tandem to create a belt and suspenders approach to risk. Poor record-keeping and minutes. Though LLCs have fewer formalities than corporations, failing to document major decisions can be a liability. If the LLC takes out a large loan or sells a significant asset without a written resolution, it appears disorganized and unprofessional to outside observers. In the event of an audit or a lawsuit, a lack of documentation can be used as evidence that the business is not being treated as a separate entity. Keeping a minute book that records meetings and major resolutions adds a layer of professionalism and legal weight to your business operations. Good records are your best defense when your business practices are questioned. Mismanaging member roles and buyouts. In multi-member LLCs, a lack of clear buy-sell provisions is a ticking bomb. Owners often fail to plan for what happens if a partner dies, files for bankruptcy, or simply wants to leave the business. Without a pre-negotiated buyout formula, the remaining members may be forced to work with a partner's spouse or a bankruptcy trustee. Disputes over the valuation of a departing member's share can lead to the total collapse of the company. Addressing deadlock and exit scenarios while everyone is on good terms is the only way to ensure long-term stability. We welcome you to subscribe to our YouTube channel for more informative videos on business, the corporations, and the law. Thank you.